Okay, good afternoon, friends. Welcome all of you here, and thank you for responding to our invitation and arriving here. And I also thank my friends from Srinagar. For the first time, we are trying to make sure that when we speak, we are available to both our friends and our friends from Kashmir. Friends, if we are able to communicate well, then we will try to make it a regular feature. So I welcome you all, and as you are aware, on my right is my dear colleague, Shri Pavan Kotwal, who is Financial Commissioner Revenue, as well as Principal. And on my left, of course, as you are aware, is Mr. Sanjeev Verma, who is Divisional Commissioner of Jammu. As you are aware, हो जाएगी उर्दू, हाँ ठीक है. As you are aware, wide Union Territory Kashmir reorganization, adaptation of state laws, the 5th Order 2020, a number of changes have been in existing laws, particularly laws related to land management. May I request all colleagues to settle down? People on the left also kindly jaiye, huh? It will be comfortable for us. You are also aware that a number of old laws, at least 11 laws, have been repealed, and at least 4 major laws have. This modification, repeal, and changes has led to a variety of reactions across the spectrum. And many of these reactions have been uncharitable. For example, some political parties have said J&K is now on. Some others have said or commented that there is no protection in J&K with regard to land, on similar lines as states. We think there is a lot of misapprehension, misinformation, and lack of clarity on all these issues. So the three of us thought we will share with you some of the salient features of these acts and inform you about some of the changes that have been made, and also explain what created those changes. Which acts have been repealed, why, which are the modifications, and what are some of the safeguards that have been built in. I think the first point that we need to understand that the entire gamut of land laws which was existing in Jammu and Kashmir was probably a product of its time, may be appropriate to the time when it was introduced, but it was essentially meant to serve an old agrarian. Quite obviously, many of these laws had become outdated, obsolete. New laws kept getting added. The system of land laws, when looked at as a whole, suffered from not only redundancy but also ambiguities and contradictions. And in many cases were clearly regressive and anti-people. Now, how was standard canals? Yet, DLEA and the Agrarian Reforms Act 1976 continued. The Reforms Act of 1976 is as we speak, 44 years old. We are in 2020 now. Yet, this act prohibited the selling of any land that was available to the tiller. So as a result, even after a generation and even after 44 years, not be sold or transacted. What was the consequence? You had a large number of so-called Benami transactions and restrictions for the next generation to transact, otherwise legitimately made available to the tiller. Another example, the Agrarian Reforms Act of 1976 had ended tenancy. Tenancy Stay on Ejectment Proceedings Law 1966 be in force. There are still more interesting examples. We had a very good law, the Prohibition of Conversion of Land and Alienation of Orchards Act 1975. Now, quite correctly, prohibited the alienation of laudable objective, but surprisingly also restricted the creation of new orchards, and to create a new orchard, the permission of the government was required. Similarly, the Right of Prior Purchase Act placed severe constraints and restrictions on an owner's right to dispose of his own property, so much so that neighbors and others had a so-called right of first refusal, both in urban and rural properties, restricting the rights of an owner to dispose of his own properties. I can go on and on and on about some of the ambiguities, contradictions. Just to give one or two more examples. There were different definitions of family across acts and laws. Provisions for conversion and alienation of laws were different across laws. So, at the end of all this, we had a gamut of land laws which was sometimes inconsistent, sometimes ambiguous, sometimes contradictory, and at other times clearly opposed to the interests of the public at large. So there was a need to, if I may say so, straighten up, clean up the system and provide a set of land laws which was simpler, prevent unnecessary litigation, and which would prevent discretionary interpretation of these laws. And as we know, any discretionary interpretation of laws leaves aside scope for vested interests to operate. So this is the background which I thought I will clarify to you. So what has been done now? As I have said, 11 laws have been repealed. And which are the laws which have been repealed? Again, I will give you a couple of examples. So laws which were either redundant or obsolete, or as I said, people unfriendly, they have been repealed. Good example, tenancy stay of ejectment proceedings. Now there was a law called the Jammu and Kashmir Utilization of Lands Act, which empowered the state to take over any land which had not been cultivated for 2 years. This has been repealed. There was the J&K Floodplain Zones Regulation and Development Act 2005. Now why has this been repealed? This has been repealed because all the provisions of this law are already available in the Water Resources Regulation and Management Act 2010. I spoke to you about the problems with Right of Prior Purchase Act. This has been repealed. Similarly, tenancy stay of ejectment has been repealed. Consolidation of Holdings Act 1962, Land Improvement Scheme 1972, Prevention of Fragmentation of Agricultural Holdings Act 1960, Common Lands Regulation Act 1956. These are some of the 11 laws which have been repealed. But I must clarify here that many of these laws had interesting and people-friendly provisions, and each of these provisions we have taken care to ensure that these are saved in the new acts or the new codes which have come about. Section 20B of the Big Landed Estates Abolition Act has now been saved as 133B of the Land Revenue Code. The relevant provisions of the Consolidation of Holding Act 1962, Land Improvement Scheme 1972, Prevention of Agricultural Holdings Act 1960 have all been brought together, consolidated and saved under Section 23 of the Land Revenue Act. In fact, the focus has been to work towards a code which is consistent, which is clear, which is unambiguous. So we have attempted to take out as many relevant provisions as possible and place them at appropriate positions in the Land Revenue Code, so that, like in the rest of the country, the Land Revenue Code, the Land Revenue Act, becomes a code, a uniform and a consistent set of laws. So, similarly, as we go forward, I will further explain what we have done. So anyway, suffice it to say at this point of time that 11 laws have been repealed, and I have explained to you the reasons each of these and how, even when we have repealed an act, certain critical clauses of that act have been taken out and placed at appropriate positions in the Land Revenue Act. Now, the second set of laws are the laws which have been modified. Now, which are the laws which have been modified? Primarily 4 laws. 1, the Agrarian Reforms Act of 1976. 2, the Land Revenue Act of 1939 AD. 3, the Land Grants Act. And 4th, the Jammu and Kashmir Development Act. Now let me talk a little about the Agrarian Reforms Act. I have seen some comments which have tried to insinuate that the new land reform system has tried to do away with the land reforms which were a hallmark of Jammu and Kashmir state. The reality is actually quite the contrary. As I said, the Big Landed Estates Act had in any case been superseded by the Agrarian Reforms Act. So the redundant provisions of the Big Landed Estates Act have been done away with. But as I said earlier, some of the relevant provisions such as 20B have been saved, and the Agrarian Reforms Act stays very much in place. In fact, if anything, the provisions of the Agrarian Reforms Act have been tweaked to remove people unfriendly provisions. For example, I mentioned about the fact that people who had legitimately got possession were unable to sell. So the amendments in the Act permits sale by the tillers after 15 years of ownership. Certain provisions in the old Act allowed erstwhile owners to continue to file resumption applications. That be done away with by providing a sunset clause and therefore disallowing new resumption applications by landlords. There is a time-bound disposal provided for all pending and residual matters. So as I said, if anything, by permitting sale of land by the tillers, by disallowing resumption applications, time-bound disposal, we have ensured that the law has become more progressive, more people friendly and cleaner. Now, what about the Land Revenue Act? As I said, the attempt has been to develop the Land Revenue Act as a land code to provide contradictions, to prevent contradictions, to avoid multiplicity of laws, and to provide for certain progressive provisions such as setting up of a revenue board, regional planning for regulating use of land. The important provision that I want to draw your attention to is that under the new land laws, agricultural land can only be sold to agriculturists. Now, how is agriculturalist? Agriculturist has been defined as a person who cultivates land personally in the Union Territory of Jammu and Kashmir. A lot of people, as I said, have spoken about there not being adequate safeguards. I wish to emphasize and re-emphasize that agricultural land can only be sold to agriculturalists, and agriculturist is defined as somebody who cultivates personally within the Union Territory of Jammu and Kashmir. So by implication, agricultural land cannot be sold or alienated to anybody who is from outside the Union Territory of Jammu and Kashmir. In fact, we have gone one step further. Any domicile of UT, anybody who is a who is a resident of UT but not an agriculturist, not an agriculturist means not in personal cultivation, can also not buy agricultural land. The terms agricultural land and agriculturist have been unambiguously defined, and I only want to draw one more attention to one more point, which is that the agriculture has been expanded vastly in scope to include not just agricultural activities but also a whole series of horticulture activities, a whole series of agro-based activities, including fallow land, animal husbandry, poultry, etc. So the provision of this one clause alone will ensure that more than 90% of land in the Union Territory of Jammu and Kashmir, which is agricultural in nature, remains protected, inalienable, and with the people of Jammu and Kashmir. I mentioned to you about the other progressive provisions, the Board of Revenue, for example, which is a multi-member body now and which has been given various powers to regulate, powers to manage development plans, etc., etc. So I spoke about reforms and how we have tried to protect that. I spoke about how more than 90% of the land will be protected, agricultural in nature, and this will include horticulture, this will include land in other agro-based industries, etc., etc. And I also mentioned about how we have tried to remove the ambiguities. Now the third and the relevant element in the matrix is the Jammu and Kashmir Development Act. Now the Jammu and Kashmir Development Act is a 1970 act which has gone through many modifications. But what have we done in the latest modification? We have provided for master and zonal development, and most importantly, we have provided for industrial development, setting up of an industrial development corporation. Now there have been some comments about this also, but what I want to clarify is that the concept of an industrial development corporation is not a new concept. We already have a SIDCO here which has been engaged in the job of developing industrial estates. So what is new? What is new is that these industrial development corporations have been set up through a statute rather than through the Companies Act, which gives them certain powers to protect the interests of the state here, insofar as it relates to ejectment, insofar as it relates to recovery of dues, insofar as it relates to taking action against people who may be non-compliant with the laws of the state. Now, there is one element I want to raise and draw. A lot of people have commented on the so-called Section 3 of the Act, which deals with strategic areas. And I have seen commentaries in the press saying that this is all-encompassing, this will permit the army to occupy large areas, this will give unbridled powers to the army. So I thought, let me dwell on it for half a second. Now, to begin with, Section 3 of the Land Development Act has absolutely nothing to do with transfer of any land to the armed forces. The transfer of land to the armed forces or to any other body will, for that matter, continue to be governed by the acquisition and requisition laws which we have at the moment, and places the onus on the armed forces themselves to ensure that those developmental parameters and those development regulations are met. How does it do it? Now, what are the 5 safeguards which have been provided? 1, only lands which are legitimately acquired or legitimately available with the armed forces. 2, only be done an officer not below the corps commander, who, as you are all aware, is an officer of the rank of the Lieutenant General, one of the senior most officers, only at a request at that level. 3, only be for operational and training purposes. 4, this can only be at the absolute discretion and satisfaction of the government that such conditions are met. And 5, the government is free to impose such conditions and restrictions as it may like to do so, in order to ensure that no guidelines, building permissions, rules are violated. So I want to say in conclusion, and I want to clarify, that we have to look at this entire gamut of changes, adaptations as a package. And what are the components of this package? The components of the package are to ensure I'll just finish. I will leave you free to cover the other item if you want to cover. So no, I said it half in jest, but I am concluding. So the elements of the package are modernization, ending of obsolete, people unfriendly provisions, ending of ambiguities and inconsistencies, modernizing the entire system of land management, leaving no scope for application of discretion, operation of vested interests, and attempting to prevent unnecessary litigation. So we have to see these changes not only as a major step towards development and progress, but also as a continuation of the process of ushering in land reforms, revamping agriculture, and also providing for clean and rapid industrialization, leading to greater employment avenues for the youth. What I do want to say in conclusion, and I cannot overemphasize, as I have pointed out, the Land Revenue Act, especially if you look at Section 133, provides for adequate protections against